Knowing that this game to be played, but I'm knowing that this game to be changed. I should be afraid of afraid. I'm just trying to live up to the meaning of my name. I'm just trying to live up to the in my game. I'm just trying to live up to my moment on the stage. I'm just trying to live up to the truth of my pain and the power that it gave me on the youth for today. I put and I shoot from the way. My time is money, and I ain't got a second for your flukes and your fakes.
Free legal advice. Please share this with your friends, whoever may be in need of legal advice. And this is the 101 level. It's levels to this. We're not going to just start out giving you all the jewels and dropping those at the same time. First, we want to start off with is some basic stuff to understand the court system and some other things that I wish that, and I'm sure that some of my other attorney friends wish that you would know to kind of help make their life easier and your lives easier as well. Rule number one, get an attorney, or at least consult with an attorney before you start showing up in court. So they have legal aid, which is for a lot of the civil cases, which legal aid is probably swamped. So if you got long money, please donate to legal aid so that you can help them take more cases and have more resources, because they are sorely needed. Legal aid is for civil stuff. If you have a criminal charge, then you will go to the public defender's office, or you can be appointed a public defender. I'm sorry, not going to go to the public defender's office. In the city of Charlotte, they have a self-serve center. Now, it's only open from certain hours. I want to say 9 o'clock to like 11:30, but they can kind of give you some resources. They actually have seminars as well, where you can get consult with people on civil things. They have some material you can look through what's going on and help you file some papers if you want to represent yourself. Now, why do you need to consult with an attorney? If not, hire one. Some of you like to try to go the pro se approach, and that's cool. Maybe it's worked out for you 1 or 2 times, but even if you've had success in the past, you can change one fact, one thing, your whole case changes. And that goes from it being a different judge, a different prosecutor, the law changing. One fact can change your whole thing. And so I see a lot of people in court, especially the pro se people, and they'll for traffic tickets, for example, they may be doing okay for a little while, then they start going left, spitting these urban myths that they've heard, and just taking up a lot of the court's time. So the courtroom and the judicial system is kind of built on efficiency. That's why there are a lot of pleas, like 95% of stuff is played out, probably higher than that depending on what jurisdiction you are. So with that being said, we don't like sitting here watching you struggle through a trial, whether it be criminal or civil, because people have cases that need to be heard, and there's a lot of cases that need to be heard on every level. So if at least you know what you're doing, you're not wasting everybody's time watching you sit here and struggle. And a lot of times with some of this traffic stuff, you try something, you take it for trial, and then you end up getting the same thing you would have if you would have just took a plea in the first place. People go through these long trials, and I see frequently they'll get an improper equipment. And if they're not lying on the record, they could have got that off top. But I guess they feel better. Everybody's entitled to their day in court. But I will say this, if you are going to have a pro se traffic trial, don't get on the stand talking about, oh, I was only going 10 miles per hour over the speed limit. You've kind of convicted yourself. Just some free legal advice if you're going to do it yourself. Now we're going to talk a little bit about public defenders versus court-appointed attorneys. There seems to be some confusion. The public defender's office is its own office within itself. And then the court does have attorneys who are appointed from the public defender's office. But then there's this separate section, which is different from the public defender's office, which are private attorneys who are court-appointed as well. They don't work with the public defender's office. They often work for themselves, and they take cases for themselves that they get paid for. However, they are contracted with the state or local government to take on certain cases that are conflicted out from the public defender's office. So what that means is you could have an actual public defender, which these people do so many cases, they're overburdened, but at the same time, they know their stuff because they do so many cases. The difference with the public defender's office, they can't give you the same level of customer service and answer your call and do some of that. But that doesn't mean they don't know what they're talking about. That doesn't mean that they don't care. Of course, it's all based on the individual. Now, the court-appointed people who don't work for the public defender's office, that's where it can kind of get a lot more messier than what you would expect. Some of this depends on if you're a small town versus a big town. You have different levels of experience all throughout. There are different requirements in different areas to get on, so don't lump them all into public defenders or you're a free attorney. Some of y'all don't even know what that means, but it is what it is. Just trying to help clear up some of the ignorance on what the public defender's office does. But in either event, go into what you're doing knowing what you're talking about. Seriously, it does us all a favor. Number two, we kind of explain the North Carolina court system, which there's infractions, misdemeanors, and felonies. In district court, that's where a lot of misdemeanors and infractions are handled on the criminal side. Also in district court, these are cases that are under $25,000 in damages. In superior court, for the criminal stuff, this is where felonies are handled. Sometimes misdemeanors are appealed to that level, or they're brought up with other felonies. That's what superior court is for, and that's where your jury trials are. In North Carolina court, the district court is the court of convenience where you can get a lot of stuff done without a jury trial. But you do have a right to a jury trial, which is why you can appeal things to superior court on the criminal end, so that you can have your day in court and have 12 members of the jury listen to your case. Also, in the civil side, you have small claims, which these cases are cases where the amount of controversy is under $10,000. So just kind of know where you should take your case, whether it be small claims under $10,000, district court under $25,000, and superior court in excess of $25,000. There's also some exceptions to certain types of claims, but we're not going to get into all of that. Then there's also clerk of court special proceedings, which are foreclosures, guardian ad litems, some estate work. Those are kind of where you should take the appropriate stuff. On the criminal side, and also in court, I think I covered some of this. The ignorance of law or the ignorance of procedure is not an excuse. So please stop with the urban myths. I can't stress this enough. I have people say, well, this officer didn't read me he didn't read my Miranda rights. But your son didn't give a statement, so that kind of doesn't help him as far as getting him out the woods because it's on video. He didn't have to say anything to the officers. They watched him do it. And with some of these traffic tickets, you say, I'm racially profiled, which is possibly true. Depending on where you live, that could happen a lot. But if you admit to speeding or you know that you weren't traveling at speed, they probably had a good reason to pull you over if you were not traveling within the speed. Now, of course, there's numbers of how many black people pull over versus white people, and depending on your jurisdiction and officer, there may be some disparities there because they may be only pulling over black people who speed. But are you going to do the research to see and prove that? You just can't say that this is racial profiling without some supporting evidence. Now we talked about getting an attorney on different things. How should you choose your attorney? Well, first and foremost, with all things, do your research. You can Google your attorney's name if you know your attorney's name, or you can just Google and look at certain reviews, word of mouth, talking to people who've been through court. If you want to find out an attorney's name, or if you've heard something, you can go to ncbar.gov and they'll tell you some basic contact information and level of experience. One thing I do want to stress is for traffic tickets, when it comes to customer service, you have to answer the phone, but we don't need you all to call every day to handle your traffic ticket. I promise you. I'm not going to give you all the jewels and tell you what we do in the back room, because really, how we resolve traffic tickets is we play darts, and whoever scores the highest gets the best deals. And since I used to play pitcher back in the day and I had a great arm, I get a lot of better deals for my client. Now I'm just kidding, but seriously though, you're paying for us for our experience and our relationships and a lot of different things. So it's good that we set the expectations, but for traffic tickets, you don't need to contact your attorney multiple times a day. Once we get your record, we know the basic rules and policies of that particular district. We can work that out depending on what you tell us that you need, but you don't have to tell us that 10 times. one of the pitfalls I want to say, if you're looking for an attorney or shopping for an attorney, and you come to the consult and say, I've been through multiple attorneys, I've hired and fired this person, or I didn't like this person, most attorneys are going to look at you like, what's wrong with you for going through all these attorneys? You might be the problem until you say something otherwise, and lets us know that you're not. And if you are talking bad about your previous attorney, it's fair for us to assume you're going to talk about us if we aren't perfect. So keep in mind how you present yourself and how you come off when you're talking about, because this isn't just a, I'm hiring you. We're beginning a relationship in which we'll be working with each other, and we have to set expectations and guidelines of how our relationship is going to progress. So just because you got money doesn't necessarily mean the attorney wants to take the case, and that's just real talk. In my younger days, it took a lot more cases that I probably didn't want to take. I'm not at the same place where I was back then. Now, I also want to understand, you ought to understand the level of, I guess, completion of what it is to mean to retain an attorney. So I don't have the same freedom because I do criminal law. And once you make an appearance, it's a lot different if it's family law and they have different motions, different things going on, or if it's a civil case. So whatever the terms and conditions are that you agree to with that attorney, if you do not fulfill, they can drop you. And so I haven't been through that experience. I don't know what that looks like, but I hear people complaining. I paid him all this money and he didn't do this. I paid him all this money and he didn't do that. And that's a different, I can understand from a layperson standpoint that some of these legal fees are pretty high. And I'm not going to deny or shade that, but if you didn't reach the amount that was agreed to, they can drop you. It's in the contract. Make sure you read over the contract. If you have a retainer and that money runs out, they can potentially be ice cold and just drop you. If you have an hourly fee, that means you're paying by the hour, and they send you that bills and you fall it off. So make sure you read and understand the fine print and get that so that you understand fully what it means once you hire an attorney, what it means to hire an attorney. If you reaching out to someone as a quote unquote favor, and so you know an attorney and they say they're going to look into something for you, doesn't necessarily mean an attorney-client relationship has been curated. But that is why you need to get certain things in writing. You need to have I fully retained you? Have I done what I needed to do to get your services? Because people show up and say, well, I put something on it. Well, that don't mean that you retain them. And you can make limited appearances depending on what the case is and where the case is. But at the end of the day, this is why we need more people in legal aid and more resources for legal aid for some of the civil stuff. And we also need more public defenders for a lot of the criminal stuff. Number 5, once you choose us or hire us, allow us to do our job. To be completely honest with us helps maximize our ability to do our job. There's some stuff that we won't know and due diligence and discovery won't cover. Sometimes it's something frivolous, like, yeah, I ain't do it. And then we watch the video, we're just like, dude, you're right there. So you got to give me something, for lack of better words, up front to help me prepare so that we can cover every eventuality. Don't lie to your doctor, your pastor, or your lawyer. Because if you don't know the law, you don't know what's relevant. And if you don't know what's relevant, you don't know how you can be affecting your case. So I get tired of seeing pro se people doing a decent job because they know something or they may be smart, but then they just go super left. If you want an update from your attorney, understand that I have more than one client, and a lot of these attorneys have more than one client. We just give you the illusion that you're the only client. So that's why it's important to set the expectations so you can hold your attorney accountable of how much contact you need. Definitely be reasonable. But if you're calling me 4 times within 15 minutes and this ain't an emergency, you kind of diminishing the value of how we're going to treat this relationship. At the end of the day, if I'm in court all 4 times those 15 minutes and I see that you called 15 minutes, 4 times in 15 minutes and I'm in court and I can't answer the phone, and then I hit you back and you're just like, man, well, what happened with such and such? Or what happened with such and such? Like, I wrote you an email with that last week. You didn't read your email? Oh, my bad. I didn't get the email. Okay. Sounds good, but yeah. So just seriously, just respect our professional judgment. This is what you're hiring us for. And if you don't especially, I hate this too, and I can understand other attorneys may feel the same. If we're advising you to actively do something, let's say it's a business relationship, and we're saying this is how you proceed. Yes, you can proceed at your own risk, and maybe you just want to know your options. But some of the time, it seems like a real waste if you're going to hire someone who has professional experience and they're giving you their professional advice, uh, so you can make an informed decision. It's just frustrating to watch clients pay us to do the exact opposite of what we told them. And seriously, I really hate when I get a great deal banged out and you say you want this and you say you want that, and then we get you deferred prosecution, which means you can get the case dismissed, and then I have to call you a million times for you to do your community service. Like it's my case. I've already been paid and I can walk away, but because I care, you put in that time, and then you go against everything we told. We told you they're gonna drug test you before you get in the program, and you're still gonna smoke. And then it's gonna take a while for it to clear. Just take and respect your attorney's professional advice. And if you don't trust them, don't hire them. Go somewhere else. I understand that some of it is a trust building relationship. It's a crapshoot. You don't know the attorney off top. But once you hire them, you're paying them to represent you. Why would you do something against what you're paying to do? Criminal cases. Whew. We can talk about this all day. First off, I would strongly encourage you don't do the crime. Secondly, I have to import this because people still don't seem to get it in 2016. Do not believe everything that the cop says. If a cop tells you, yo, if you tell me what happened, I'm going to get you a lighter deal, don't trust that. No, seriously. He can speak highly of you all you want, but it's the prosecutor who has the decision to accept that or respect that. Cops can, in fact, lie to you. I just want you to know that. Despite what you've heard, sometimes they lie in the reports. Some of them are even bold enough to lie on the stand. They're not afraid to lie to you, especially if they're trying to get consent or to get you to write a statement. If you're asked for a statement, don't say anything. I cannot stress that enough. There have been so many cases where people, for lack of better words, make the cases for the cop by just talking. Just ask for your attorney and shut up. It's just that simple. Even if you actually are innocent, you don't know what the cop is looking for. You don't know how they see you. You don't know what key buzzwords or things that you might have said that just kind of made them look at you like, oh, he is guilty. The whole purpose of the interrogation room is to, for lack of better words, get an admission of guilt. It is structured to be isolating. It is structured to be put you in a level of fear, which is why if you're going to go in there, you should go in there with an attorney. Point blank, period. So when you start saying things and they start feeding you information subliminally by telling you, well, the shooter was wearing a white shirt, he was this and the third, da da da. What color shirt were you wearing? Well, I was wearing a white shirt. Aha! And now you feel like in your mind he got you because you did admit to a white shirt and you're defensive and you appear defensive. They put you in a defensive place, in a defensive atmosphere. So this is why you don't say anything and you go with your attorney if you're going to go at all, because there's a difference between being forced to come down there and being asked to come down there voluntarily. So with that being said, get your attorney. Don't say anything. And for the parents, I do understand you may want to discipline your child or have your child, for lack of better words, learn a lesson. And that's great. But I would strongly encourage, don't send your child down to the precinct. Talk to an attorney first. Don't bring them down to the precinct and have them give them statements, because just because you're their parent doesn't mean that what you say or what they said to you is confidential. And what they say, we think, oh, it's not that serious. And now your son is caught up in the system because you made them go down there and give a statement without hiring an attorney. Seen this fact pattern so many times. I do understand you want your child to be responsible. And I do understand that you do want your child to learn a lesson. But at the same time, from an attorney's standpoint, we represent the child, not you. And then on top of that, what happens is once they get in the system, something happens that you didn't foresee happening. And now you're in panic mode because you put your child in a bad position. Don't do it just off top. More importantly, not just from the children, but from all people. And this is more personal than anything else. Just keep it 100. I'm tired of seeing parents, family members, other people putting up ridiculous attorney fee amounts for someone they believe is guilty. Believe is innocent. Sometimes they know their son is guilty or daughter is guilty. Uh, and you got the church vouching for you. You got all these people saying he didn't do it, he didn't do it, and you know you did it. You can't tell your family all the facts, and you shouldn't. You should only tell that to your attorney. But if you know you did something wrong or something suspect, don't have the church and everybody standing up here vouching for you when we get to trial. We watching a videotape of you doing everything that these people risk their credibility to say that you didn't do. Or they putting up a family putting up bond money or putting up property for bonds, and you know you did it. That's just a little personal thing. I'm not gonna say that's for everybody, but yeah, don't be having your folks put up their house and all of this for bond, and then you don't even want to show up to court because you know you did it. Just keep it 100. So for the business clients, we'll kind of keep this short. I should not have to say this, but clearly I do. Please get your contracts in writing. And how descriptive and detailed that writing is up to you. The more descriptive and the more detailed, the better. But stop with all these oral contracts for thousands of dollars. There are some things that maybe you do know, maybe you don't know, depending on how many transactions you have done. There's certain things called the statute of frauds, parole evidence, merger clauses, credibility, people's memory going, missing signatures. All of these things can prevent someone from saying that this is what was said, even though this is what's not on paper. This can prevent the admission of pertinent evidence in your case. So when you're talking about when the contract breaks down and somebody doesn't uphold their end of the bargain, these are things that you want to have in writing to kind of prove and back up what you say. Just because someone said, I will do such and such, does not mean that they will do such and such. And I understand this happens on so many levels because the contract is just all for consideration and acceptance. And so that means a lot of different things, from leases to contracts for services to contracts to rent a venue. All of these things, contracts is a very wide variety of things. But make sure you get something in writing, have it explained to you to your satisfaction so you understand it. Preferably, you should get an attorney to draft it for you if you're the drafter, because any ambiguity or lack of clarity is construed against whoever created the contract. Most importantly, read the thing. I mean, my intake agreements and some of my contracts, less than a paragraph of reading. And then people ask me basic questions, and I'm like, it's just a paragraph. Read. Maybe you don't have time. Make time for it. Because at the end, if you're talking about putting up $10,000, $15,000 on a contract you haven't read, and then something goes wrong, and you have to go to the court, and they say, well, this was explained to you, point number 1.28. So read your contract. We have difference of opinion on a lot of things. So sometimes people think that they're on the same page. This is why you have it explain it to you to your satisfaction. Contracts in the business setting, you won't believe how many sophisticated business people we have come through who signed off on contracts or started services without a contract, and then we have to go through all this and there's no paper trail. It's 2016. Do better. On the same line, number 8, let's talk about these leases. We do a lot of landlord-tenant stuff. We represent both sides. We represent property managers, individual landlords, and then often we represent tenants. What I don't understand from the tenants is, why do y'all play with where you'll be living? Number 1, read the lease. This goes back to what we said earlier. And if you don't understand certain things, you can go to legal aid. Depending on where you are, legal aid may or not accept you, because they are kind of swamped. In Charlotte, you can go to the self-serve center and get help. You can call the CAM law offices and we'll give you some advice on certain things, but we're not out here working for free. I've heard a lot of, a landlord told me this and landlord told me that. He told me if I just pay my money, then I can stay in court. Yeah, but what you didn't understand or didn't read was that only applies before the judgment for possession and money was entered. So if he told you you can pay the money, you can stay, but then he got an order for your eviction and possession, and for money, and then you pay him, you might have just given up a lot of money for no reason, because after the order for money and or possession is issued, you do lawfully owe him that money, and you're not going to necessarily get possession back. It's kind of in their, the ball is in their court whether they do or don't want to do that. So number one thing is show up read the contract. Number two, if you don't have attorney, at least you don't have an attorney, you're going to show up to court. I mean, at least show up to court. They will issue a judgment against you if you don't show up and the landlord doesn't do what they say they would do. And what I don't understand, and maybe you can help me with, if you owe someone money and they have filed a lawsuit against you to get their money, and they tell you, oh, it's fine, you don't have to show up to court, and this affects where you live, why would you not show up to court just to make sure that they do exactly what they say they're going to do? Then you don't even look at the judgment the day after or the day after that, or you don't look at the judgment until after the sheriff shows up with eviction papers, which at that point, there's very little that can be done when the sheriff shows up with eviction papers. So if you can't go to court for whatever reason, people work, they have emergencies, at least go check in at the clerk of court and see what happened in your case. Was the order for ejectment signed off, an eviction coming within a short amount of time? Did they rule in your favor? Did they dismiss the case? You have an obligation. I would think if this is determining where I live, I want to go know that information and show up at the clerk of court even after the fact and say, well, what happened on my court date? Very simple. And if the landlord and you have had issues before and you don't believe that they're a credible person, I don't understand why people take the landlord's word that they're just going to dismiss it. They're serious about their money. So you should be serious about yours. Number 9. Oh, just some last thing. So you have 10 days from the date of entry of a judgment, keyword 10 days, small claims, to appeal. So if something doesn't go right within the first 10 days after the judgment, you have the option to appeal it to district court from small claims. So this is why time is of the essence. You need to find out what happened in court sooner before later if you weren't there for yourself. And if you're going to hire an attorney, don't wait until after the judgment. I mean, like we said, consult with someone in the beginning if you can't get your paper right. See what options that you have to kind of get some advice, if not the full attorney for the proceedings. And I do understand in certain cases, if you ain't got money to pay rent, you don't have money to pay an attorney. But if this affects where you live and where your stuff is, sometimes you have to make sacrifices if at all possible. So we're talking about judgment, making a decision. On number 9, we want to talk about knowing when to quit. If you've been offered a plea, especially if you know that you did it, you have to know when you're up. And in the civil thing, you have to know, hey, I don't have the resources to actually take this to trial. You have to know when you're already ahead and know when to quit in the settlement. So if it's a criminal case, you have 3 options. You can plea, you can trial, or you can continue. Now, there's some motions in between, but for the most part, you can have a plea, a trial, or continue. Everyone is not getting a dismissal. Let's just keep it real. Especially for these traffic people say, I want stuff dismissed. But in the consultation, you told me you're speeding. What grounds do you think you should get a dismissal for? Well, this is my first one in X amount of years. That don't mean that you should get a dismiss. That means that maybe you shouldn't be punished as severely. Well, so-and-so got me improper equipment, and improper equipment is not a dismissal. Improper equipment means that there's no points on your record for driving or insurance points, but it does not mean that the case was dismissed. If you have to pay court costs, that means your case was not dismissed. If it's dismissed, you walk away and it's free, minus the time that you invested. And if you get something dismissed, please consider the seriousness of getting an expunction. For a lot of this criminal stuff, civil, there aren't expunctions for a lot of civil stuff. But if it's a criminal case and you get a dismissal or a not guilty, get it expunged as soon as possible. Don't wait till 10 years down the road and someone says, we're denying you a job based on this charge, but such and such was dismissed. Yes, but we can still see it. When you get a dismissal, that just means it's over and you were found not guilty or the case was dismissed. To take it off of your record so no one can see it, you need an expunction. And those take a lot of time in the state of North Carolina, anywhere from, 4 months to 12 months. And a lot of that is time to spend in the SBI. So after you send, or the attorney sends off the paperwork, is going to sit in the State Bureau of Investigation while they run certain information on you. And that time is what's going to take up a lot of the time. So don't wait until you get to the time where you need a job to apply for, or you lost a job, and then talk about, well, let me get my record clean. Do that now, as soon as the case is dismissed. Or if you're under the age of 18, right there when you turn 18, get that stuff off your record, because it takes a long time. And a lot of stuff people call an emergency is too late. Your failure to plan does not constitute an emergency on our end. And there's certain things we just can't move up at the speed that you'd like to move. But on knowing when to quit, knowing when to call it quits, first and foremost, make sure you fully disclose all the information to your attorney. Let's just start with that. Then secondly, trust their professional judgment. If you got in a car accident and you don't have any medical bills, you don't have any injuries, you don't have any of these damages, stop talking to your attorney. I want $100,000. And you can want that all you want. We all want $100,000. But the reality is, when it comes to dealing with the insurance company or whoever we're dealing with in the negotiation, they're going to look at certain things that are considered damages. And if you ain't got it, you ain't got it. And your attorney should be looking at, well, how much was the medical bills? What were the lost wages? What's your pain and suffering? And you can go over that and consult with that. And they're going to say, well, this is the figure that we think we can reasonably get. This is what we'll negotiate, But stop coming with these ridiculous expectations that, well, so-and-so got $21,000 and Well, so-and-so might have lied to you. Let's just start with that. And then so-and-so's case may happen in a different jurisdiction, a different time, different law. Trust your professionals' advice. This is what you are paying and hiring them for. This is why you have a good mutually set expectation for what's going on the front end, so that on the back end stuff is a lot more easier. And on the criminal end, everybody wants to dismiss, and that's fine. That's the goal, or not a dismissal, if not a not guilty. Sometimes you have to take stuff to trial to get better things than you would. But especially if you know that you did whatever it is that they're accusing you of doing, understand that there is a structured sentencing for depending on what you did. So if this is the type of crime that you did and this is your record, this is the range of what we're looking at. Charges can be reduced, charges can be modified, penalty can be modified, but just understand that if you committed a very serious felony, you're just not walking out that door if they have the evidence to prove it. So the offers that the prosecutors make, which on the from criminal side and the civil side, if a prosecutor gives us an offer, we have to give that to you within a short amount of time so that you can understand what you are rejecting. If we are given an offer on a settlement, we have to give you that offer within a short amount of time so that you know what you're accepting or rejecting. So even though sometimes in negotiations on civil and criminal side, stuff doesn't start off where you wanted to start off, doesn't mean that the person's not doing their job. This is just part of the process. This is why you should have faith and trust in your attorney, because this is the process that we go through all the time. It may seem new to you because you may not be going through this, and we may not start where you want to end up, and we may not end up where you, for lack of better words, wanted to end up. But if you trust your attorney, you know at the end, this is where you have decisions. You can either accept the settlement, reject the settlement, accept the plea, reject the plea. But the next thing that is we're going to trial, or we're filing some motions, and you still have the same thing. If they don't give you, for lack of better words, what you want, which I feel like there's some issues of entitlement. I'm entitled to such and such and such and such. And we come across that sometimes. Doesn't necessarily mean that you feel that you're entitled to it, that you're going to get it. So when you have a trial, understand the commitment that you're making to that trial. Some people don't necessarily plead because they're guilty. Some people plead, and I've had this said on multiple times, man, I got to go to work tomorrow. I ain't got time for this. You tell them, hey, this is the possible ramifications if you do that. Because sitting in a trial in certain counties can mean you lose a full 2-3 days of work. For misdemeanors, let alone if you're on for the felony trial calendar and you have to be on standby and be able to leave within an hour to come to court and sit there and start up a jury. It's a serious time commitment of your time and energies and the attorney time and energy. So when you talk about a trial, have them advise you about everything that's involved, how many people need to show up on your behalf, how long they're going to need to be there, how long you're going to have to be there. Because trials aren't simple things. It's not like, oh, we just show up and then we just go. Even if we're on calendar, doesn't necessarily mean we're going to go at the time that they say we're going to be here, especially in district court, because there's a whole bunch of other people who are here for the same thing you are. And I understand everybody thinks that they're the protagonist of their story, but not everybody's the protagonist. Last but not least, my personal pet peeve is do not waste my time. Don't set a time for a meeting, consult, etc., then call me 30 minutes after the fact talking about you're going to be late or can we reschedule. If you're going to be late, let me know on the front end. Life happens, I get that. But do not waste my time. Do not show up late to court. Do not miss your court date. These are very serious things, and depending on the county, you show up late, you might as well not show up at all. Call your attorney and be like, hey, we got to do what we got to do to explain to you what the order for arrest means and how we can get you back on the calendar. Do not be late. You're wasting our time. The court's time to say the court is a lot about judicial efficiency. How many people can we get in and out and kind of process and semi-help within a short amount of time? So if you know you have something coming up, just talk about it. Communicate. Let your attorney know so maybe they can go do something else and come back to you. So those are the 10 one-on-one level things. We're talking about giving out free legal advice. We'll take it to the 201 level next time. Appreciate your time. This is Marcus Aurelius signing out. See you next week.